How many prior convictions?
Your Honor, I show this as the seventh,
Okay.
but he does have one prior felony, OVI, which was in 2023 out of Hamilton
Throw this
County.
away. Okay. Sorry, Your Honor. State of Ohio versus Tony Baker. Case number is 26CR43324. Mr. Baker is present today with his attorney, John O'Shea. The state is represented by Carl Harris. According to this, Mr. Baker plans to plead guilty to operating a vehicle under the influence of alcohol. That is a felony 3 that carries up to 60 months in prison, a maximum fine of $10,500. There's a mandatory prison term of 60 days required. The parties are making a joint recommended sentence for 48 months in prison with possibility of judicial release into a CBCF after 24 months. Further, the parties agree the defendant's license will be suspended for life. Mandatory fine of $1,540, and the license suspension is 3 years to life. Okay, have I stated that correctly, Mr. Harris?
Yes, you have, Your Honor.
Ms. Shai?
Yes, Your Honor.
Mr. Baker, do you understand what you're looking at, sir?
Yes, sir.
You could be sentenced to 60 days, up to 60 months. You're agreeing to 48 months with a possibility of getting released after 24 months, but no guarantee. Do you understand that, sir?
Yes.
And you're agreeing to a lifetime suspension. Do you understand that?
Yes.
Okay. You don't have to do this. You're entitled to have a trial, or you're entitled to plead guilty and let the judge sentence you. It's up to you. If you have a trial, you're entitled to a trial by a judge or a jury of 12 people. Do you understand that, sir? You have to answer out loud.
Yes, sir.
We're getting a record of this. What is your plea to operating a vehicle under the influence of alcohol with how many prior convictions?
Your Honor, I show this as the seventh,
Okay.
but he does have one prior felony, OVI, which was in 2023 out of Hamilton County.
Okay. What is your plea to operating a vehicle under the influence of alcohol?
Guilty.
Accept your plea. Make a finding of guilty. Anything from the state on sentencing?
Your Honor, he does have 70 days of jail time credit at this point, and nothing further other than...
This case wastes no time escalating. A repeat offender now facing his 7th OVI walks into court already carrying the weight of past mistakes. The stakes: prison time, a lifetime license suspension, and a plea deal that could either limit the damage or lock him into years behind bars. But here, where it gets intense, what seems like a straightforward guilty plea is about to unravel in real time. Miscommunication, second thoughts, and a last-minute twist could change everything. The real question is, did he truly understand what he was agreeing to, or is this about to turn into a legal reset?
And we would ask that the court adopt the recommendations of the parties, that being 48 months in prison with possibility of judicial after 24 months, and that would be into a CBCF. And also ask to adopt the recommendation of the lifetime license suspension.
Ms. Shai, anything on behalf of Mr. Baker?
Your Honor, we would ask also that the court adopt the recommendation with regards to the sentence and judicial release after 24 months into a CBCF. Mr. Baker does understand that he does have a problem, and he welcomes the opportunity to go into a program. We would ask that the court, think about the lifetime suspension. I do understand that it can be revisited by the court at a later time. Otherwise, we would ask that the court recommend or adopt the recommendation with regards to the sentence.
Is that 4-month period, does that include the time he's served already?
He has to do a mandatory 60, so
He's already
it's
done
going to
that.
overlap. Yeah, it's going to overlap. It has to be in prison. The 60 has to be in prison. I don't think it's going to be an issue. He will get 70 days of jail time credit. That will credit into the, I guess if you're asking for the 24 months.
That's what I'm asking.
Yeah.
Okay. All right. Is there anything you want to say, sir?
No. Just that I apologize for my actions.
Okay. All right, the sentence is 48 months. The record will reflect there's an agreement that he's can apply for judicial release after 24 months with the understanding that he would agree to go to a community-based correctional facility at the end upon being released from prison. The license is suspended for his lifetime. The fine is $1,540. I'll waive costs. Is there anything else, Mr. Harris, other than appellate rights?
No, Your Honor.
Ms. Shy?
No, thank you, Your Honor.
Mr. Baker, do you have any questions, sir?
No, sir.
You have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. Cannot afford an attorney will be appointed to represent you. Any document you need will be provided at no cost. Okay, that's all. Ohio versus Tony Baker, case number 26CR43324. Mr. Baker is present with his attorney, John Ashai. The state is represented by Carl Harris. We are here after plea and sentencing. Although the sentencing entry has not been filed, I'd say we finished this case about 5 to 10 minutes ago. Ms. Shah, you wanted to be heard on this.
Yes, Your Honor. After the plea was taken, I guess between the communications between Mr. Baker and his daughters brought some concern that they believed that it was two years, and then after 1 year he would be released into a CBCF. So I wanted to make sure that Mr. Baker understood what he entered a plea to. So I went back and I spoke with Mr. Baker, and it seems that he may have confused months with years or something, because that was his understanding, that he would be that it would be 2 years and then being released into a CBCF after 1. We did discuss what the plea offer was before court 2 times, one while he was back in the holding cell, and then when we were out here, and then again, Your Honor went through the information with him as well. But I do truly believe that he may have been mixed up between the months and the years that he would be serving. So based upon that, we would ask to withdraw his plea at this time, but he would still like to enter an open plea.
Mr. Harris, any input on this?
Your Honor, the only thing I can say is that I believe the defendant made a knowing, intelligent, voluntary plea. I don't believe there's any showing of a miscarriage of justice. We discussed this. It was put in writing. It was presented to the defendant. He signed that. Seemed like everything was smooth. He came before you. You indicated what the sentence was agreed upon. I know that Ms. Shai was here talking to him for quite a while as well, so I'm not sure. I was kind of shocked when she came.
Right here, you're seeing a critical moment in plea-based cases. The defendant accepts responsibility, apologizes, and the judge moves forward with sentencing based on a joint recommendation. Now, legally speaking, this kind of agreement usually signals closure. the prosecution and defense are aligned, and the court often follows that recommendation unless something feels off. But notice the weight of this deal: 48 months in prison, a lifetime license suspension, and only a possibility, not a guarantee, of early release after 24 months. That distinction is huge. A possibility is not a promise. And here's something to think about when someone with multiple prior convictions reaches this point. Is the system offering one last structured chance, or simply formalizing an inevitable outcome?
Back and said he didn't understand what he had just done. So that's the only thing that, on behalf of the state, I would have to say.
Okay. Sir? What was it about the questions and answers I asked that confused you?
Like she said, I was just, I thought it was 2 years release in 1 year. I didn't realize it was 4 years and release, possibly released on up to 2 years, after 2 years. I don't know if it's worse for me to retract this and do an open plea. I don't know.
Well,
We're just,
it has not been filed.
it just seems like a long time. But I'm guilty of.
Well, you need to understand, you could get 60 months.
Which is how long?
5 years.
5.
5 years?
It's not likely since you're entering a plea, but the maximum sentence in this is 60 months.
Which is 5 years.
Right.
So I'm getting 4 as a.
Yeah, you agreed to 4. And then there was I was a little concerned about this because, but I went along with it, because the CBCF as community-based correctional facility generally requires an assessment and identify a level of care to see if he's an appropriate candidate for that. So I'm going to permit him to, I guess does he want to withdraw the plea, or does he want to withdraw the agreed sentence?
It would be the agreed sentence. He still wants to plead to count 1 with count 2 dismissed.
Okay. Then I'll order a pre-sentence investigation as well as an evaluation to determine if he's eligible to serve any part of his sentence in a community-based correctional facility. Probably would have to be updated if he goes to prison, which he has to do. Depends on how long he's there. But it could always be updated. So I'm just going to...
Your Honor, my only concern is the agreed recommended sentences on that plea form. So I think it's, I can reprint and maybe replace if it'll come out the same. It may not.
Can you just do a new one?
Yeah. Yeah.
He just enters the plea. I'm going to throw this away.
Okay.
Sorry, Your Honor. And thank you.
I guess I need to go over the plea again.
Well, he'll need to sign the new one.
This is where everything shifts, and it's rare to see it happen this quickly after sentencing. The defense raises a serious concern. The defendant may not have fully understood the plea, and in the legal world, that's everything. A plea must be knowing, intelligent, and voluntary. If there's confusion, especially about something as major as years versus months, it can open the door to withdrawing or modifying the agreement. But here, the tension: the prosecution insists everything was clearly explained, documented, and acknowledged. So now the judge is balancing 2 things: protecting the integrity of the process and ensuring the defendant's rights weren't compromised. What do you think? Was this genuine confusion or regret kicking in after reality hit?
No.
Just been in the jail so long that everything echoes in there. So it kind of, messes with your hearing.
Same thing, mandatory fine, 3 for the class 2, and then up to 2 years discretionary PRC. Same thing that we went over before, except for the recommended sentence. Okay? Need your signature.
anybody in here this morning?
Okay.
Somebody put gum on that chair. He just sat there.
They're gonna do a
I'm
pre-sentence
trying to figure out who would
investigation,
have access to that chair to put gum.
and then they'll come back for sentencing. Okay?
That's bad.
Could be a YouTube sensation.
Well,
You
no,
may go through all this sentence investigation and go back to the job.
he is that.
All right. Sir, I'm going to go over your constitutional rights with me again. If you do not hear me, raise your hand or point it out to me. According to this, you're pleading to count 1, operating a vehicle under the influence of alcohol. That's a felony 3 that carries a maximum prison term of 60 months, a maximum fine of $10,500. There's a mandatory 60 days in prison that has to be served on this. There's a mandatory fine of $1,540, and there's a Class 2 license suspension of no less than 3 years to life. Do you understand that, sir?
Yes, sir.
What is your plea to operating a vehicle under the influence of alcohol?
Guilty.
All right, I accept your plea. Make a finding of guilty. Order a pre-sentence investigation. Set this for sentencing at a later date. Anything else from the state?
Not at this time, Your Honor. Thank you.
Ms. Shy,
No, thank you, Your
do you
Honor.
have any questions, sir?
No, sir.
Okay, that's all. Thank you.
In the end, this courtroom moment becomes a powerful example of how critical understanding is in the justice system. A defendant facing serious felony charges initially accepted a plea that included prison time and long-term consequences. But within minutes, that agreement was challenged, not because of new evidence but because of a question: did he truly understand what he was agreeing to? The judge ultimately allowed the process to reset, ordering a pre-sentence investigation and removing the agreed sentence, ensuring that any final outcome would be based on clarity, fairness, and proper evaluation. This case highlights the fine line between accountability and due process. Even in situations involving repeat offenses, the court must ensure every decision is made with full awareness. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.